Any mention?
Please, Lordship.
Yes.
Lordship, seek your permission to make a mention of item 23, my lord.
23 is
In the
respondent.
I'm for the private respondent number 4, my lord. Matters fixed for hearing, my lord. My lord, in this case, we had taken my lord's permission to file a short affidavit raising the issue of maintainability. So that affidavit was filed. So it should actually be for hearing on the limited issue of maintainability.
Doesn't matter. We'll take it up today.
No, I was requesting if this can be taken in the admission hearing column, my lord, instead of final hearing, because pleadings are not yet complete, actually.
Okay. Mr. S. Jindal, correspondent number
4.
4 submits that as there is a challenge to the maintainability of the writ petition, the same be listed for admission hearing. Stop. Not a. You don't want to word it. Yes, not objected to by the counsel of the petitioner for this is matter after 1 week.
1 week.
For admission hearing. Yes. Item 23. Yes.
Obliged.
Lordship, I beg to make a mention of item 18.
Yes.
Lordship, I prefer 2 weeks' time, Your Lordship.
Go for other side.
What's
What's the matter about?
Your Lordship, this is termination from service matter, Your Lordship.
22 matter now. It's now 24. Okay, 2 weeks. Yes.
Obliged, Lordship.
Yes, Mr. Sheikh.
Lordship, I beg to mention item number 16, Lordship. I pray for 2 weeks' time, Lordship, this matter. I have some difficulty to item number 16,
difficulty?
Lordship. 16, Lordship.
2 weeks on the prayer of Mr. Sheikh. Yes.
Yeah, please, Lordship, I beg to mention item number 14, Lordship.
Why?
I have some difficulties, Lordship, due to some difficulties. Did not prepare, Lordship.
Okay, 2 weeks, yes.
Lordship. Much blessed, Lordship.
Lordship, I beg to mention item number 15, Lordship.
Why?
The arguing counsel, Mr. P.K. Roy, is under P.K. Roy Chaudhary, is under bereavement. So, Lordship, I pray.
Last time was his under bereavement, correct?
Sorry, Lordship.
Last time took time because he under bereavement also.
Yes, Your Lordship.
Last occasion.
Yes, Your Lordship.
When was that?
Last December, Lordship.
Someone else died now.
Yes, Lordship. I did not inquire who has died, but he said that I am under bereavement, Lordship.
No, but last time also on December is under bereavement.
Yes, Your Lordship.
I hope it's not under long bereavement. It's 2 weeks. Yes. Otherwise, you'll do it. You won't wait for station councils. Yes. Yes.
Your Lordship, I beg to mention item number 21.
21.
Conducting counsel is indisposed, Your Lordship, Ms. N.G. Shilla.
Jamshed Ali.
Yes, Lordship.
Okay. As the senior government advocate said, we indisposed this matter for 2 weeks.
Obliged, Your Lordship.
Item number 1, supplementary list.
Number 1, 2, and 3 are connected matters against the corporation for payment of terminal benefits. May be granted 10 days time to obtain instructions.
Yes, heard so-and-so, issue notice. Ms. S.N. is present, accept notice on behalf of
The respondents.
all respondents. No further notice. List after 10 days for instructions. Stroke affidavit. Yes. Same order 1, 2, 3.
Lordship.
Yes.
Item number 4.
May please, Lordship. This is the matter of Gangbura, Your Lordship. What happened is this is late up to receipt was the Gangbura of Magurmari. After his expired, he was expired on 2nd November 2023. After his expiry, the villagers demand for fresh election, and then the district council has directed for spot inquiry. Then they have conducted the spot inquiry. In the spot inquiry, they found that there were 2 candidates. This is a private respondent and the petitioner. They were actually the participating as a contesting for the Gangbura seat. And inquiry have submitted the inquiry saying that there is a 2% who is a candidate and election need to be conducted. But despite of the inquiry report and from the demand from the villages, instead of asking for the holding the election, district council just appointed private respondent as a Gangbura without holding the election. That is the case, Your Lordship.
Where's the inquiry report?
Yes, the inquiry report is, Your Lordship.
Where is it?
That translation page 90.
90?
90. May I read, Your Lordship?
Yes.
I do hereby most humbly and respectfully beg to submit that the incident report as per your office order dated so-and-so, we 3 persons on Monday dated so-and-so have conducted the sport inquiry. As per the sport inquiry, we found that there were 2 candidates, namely Rizazul Karim and Nul Alam Sedek. During the inquiry, people from the 5 localities are present for the meeting, and from the beginning of our meeting, there were some group of people who expressed that they are in favor of holding an election, and there are other group of people who oppose that they are not in favor of holding the election for appointment of new Gangbura of Magumari village. It is stated that there are some group of people who express their willingness to support Sri Rizul Karim as a headman without holding an election. Therefore, we leave your discretion whether to conduct the election or not to conduct the election for appointment of Gangbura of Magumari village. This is the report.
So you see, after the inquiry, this annexure 4 is impugned order.
Lordship.
The executive committee is also, so they appointed as number 6 for election.
Yes.
Yes, Mr. Day, what is this?
My lord, there was election is not mandatory. There was a spot inquiry.
Yeah, but if that's view expressed that
that is the view of the spot.
If there's a consensus or unanimity, we can understand.
My lord.
Yes.
My lord, what is my submission today, my lord? I have no instruction, but as per the record, my lord, there was an spot inquiry, my lord. They have given their opinion, my lord. It is the EC who takes a call, my lord. Now, this is a temporary appointment. My lord may kindly see. This is a temporary appointment, my lord. Moreover, my lord, that will be examined. Now, his complaint and all will be examined. And my lord may kindly see that.
Where does it say temporary appointment?
My lord, is for 6 months only, my lord.
Even then, they do that, they extend it again. That's what has been done.
We'll examine it, my lord. Since the matter is before this court, my lord, I will take instruction, my lord. Let it come after 2 weeks, my lord. I will take instruction and I will submit, my lord.
In the earlier also, Lordship has passed an order, the page number 6, Lordship. That
page number?
Page number 96, that is judgment also, where para 9 very clearly stated that election should be here.
In the same case?
No,
different one, but I'm just relying that similar matter.
That was not the mandate of the court.
And the law also, that there is a provision also clearly mentioned that page annexure 5, they were it's a mandatory for holding the election. Lordship.
The council petition issue notice. Mr. SD spread accept notice on behalf of respondents 1, 2, and 3. The petition takes steps for service notice on respondent number 4. But I said AD as long as also by personal service. This is a matter of 2 weeks for instructions for affidavit.
Lordship, for typing, I pray for that file a miss case at least to suspend the impugned order. Only for typing.
Let me give some observation and stop. This matter, this matter appears to be urgent in nature, in as much as the challenge to impugn order is with regard to the appointment of respondent before without any due process of election, as has been desired as observation. Stop. This observation is made view the fact that a perusal of the inquiry report conducted by the respondents reflects that there was no consensus with regard to appointment of any particular person. Stop. Just accordingly. And so on.
Tell him.
Happy with that?
At least to suspend that for timing, Lordship.
No suspension because he's not here before us. He's already been appointed. When was he appointed?
24 January, my lord.
24 January.
And now it's almost going to 20.
Anyway, we'll remove him. There's nothing that cannot be undone.
At least that order should not be taken into effect. Only that.
No. You can't leave. You can't. That's very smart submission. You can't. Only that. That's not only that. That's everything. Yes.
Much bless your Lordship.
Yes. Yes.
Your Lordship, I pray for some accommodation. Mr. Shula is on legs.
After some time.
Maybe after
3 weeks.
some Lordship, after 1 week, Lordship.
Why?
Because I have some appointment with doctor today, Lordship. That's why I have
already
taken.
become infructuous, my lord.
It's not because of that, because I take that appointment with the doctor. That's why I have adjournment also the other case, because I need to go.
Okay. After a week, as
Lordship.
Mr. P.T. Sama has an appointment with a doctor. You want to record that also?
Lordship, I have to go to police bazaar.
Okay. And he has to go to police bazaar. No, don't record that. On the prayer, we
Lordship.
consult with pensionary personal difficulty. This after 1 week.
Obliged, Your Lordship.
Much blessed, Lordship.
Item number 2.
Police bazaar. Has this been settled?
Lord, they had given us a written proposal. We had communicated earlier last year itself that to chalk out the terms and conditions, the parties will have to sit together.
Very difficult.
So
this
meeting has
petition
not-
of yours, Mr. Chakravarti, because he'll get
We have-
similar. Whatever has been given to the other people that come to court, it'll be along the same lines.
No, we have been trying to meet, but unfortunately we could not meet. That's the problem. He has gone. What he told me that he has gone there to the office a few times, but could not meet.
Has he gone? Because last time he didn't come at all. That's what their submission.
We are not aware.
Well, I have been told that he has gone there, but could not. Well, the thing is this, that what I understand, that the shop which is in his occupation, without that being demolished also, the construction work is progressing. And
So he
we,
can-
But right now this is for the
he
future.
can continue with the shop.
he's
That is a
continuing.
stopgap
It is not,
arrangement.
it's
What
not
kind of shop does he have?
Restaurant, my lord.
Restaurant.
small restaurant. So that is not creating any problem. So now for future,
Exactly.
that
for
is
future.
the agreement I think is required.
A
we'll
week
close
or
it.
2 weeks time may be granted for them to meet the MD and chalk out the terms.
You don't seem to
Because
see
for
any
us
urgency.
to meet the
We'll give directions that you settle the matter within 1 month, dispose it of. Why keep this pending unnecessarily?
yes, yes.
Yes.
Yeah, because
What
we have
happens
already
is,
given
in
proposal
case
for.
Lordships give that direction and they don't meet the MD and the agreement is not made, the matter will not be settled. Because the PB proceedings are still
That
pending.
is the
Meeting the MD, will if my
Okay,
friend,
we'll fix a
I'll make
specific
an
date.
endeavor, my lords.
if my friend makes a little endeavor and fixes our
Yes,
time, we will.
Mr. S. Chakravarti, counsel petitioner, submits that the matter could not be settled as yet, in view of the fact that the petitioner has not been able to meet the respondent number
2.
Number 2. In this next, and due to the matter, they expected that within the next week, the standing counsel for respondent number, for the respondent number 3.
I apologize, 3
Number
minutes.
3, yes.
3.
Will facilitate a meeting to bring the matter to police
Right.
settlement just after 2 weeks.
Your Lordship has passed the order in similar matters, my lord. On those lines only, this order can be passed, my lord. The matter can be disposed of. That. Achha,
Same within 1 week.
Same matter.
Same matter. Same agreement.
It will go in the same lines only.
Same line.
Only meet, no, otherwise it's a very difficult petition.
Yes,
I
yes.
understand.
Unless you meet.
Item number
He's
3.
your classmate, no?
He is actually a little indisposed. That's the whole problem. I'll try my best.
Yes.
All right.
Yes.
Your Lordship, in this matter, we have filed a miss case
Why?
regarding
For?
impleadment of the new member, Your Lordship, of the WAF board.
Who's the new member? Roshan I Begum.
Shenaz
Shenaz
Abbas.
Abbas. You are paying for whom?
For the petitioner, Your Lordship.
Any objection?
We haven't received a copy, but we have no objection.
You give them a copy. Who are the main respondents?
State is there. And
I'm the state respondent.
We'll
You
serve
receive
the-
copy.
I've received the copy.
We'll serve the response.
This is case number 23, 2024 and WPC 26.
Only one thing, Lordship. This respondent number 8, Roshan Ara Begum, she has been impleaded twice, Lordship. So she may be deleted.
She's been impleaded twice?
Respondent number 8 and 14, impleaded twice.
She's still a necessary party.
Your Lordship, I'll take instructions in that regard.
You want to delete her and insert this new person?
No, Your Lordship. We just want to complete the new.
You want to
member.
add a respondent?
The new one.
I can find. Sorry. Respondent number, you're saying? Mr. Kharvi?
Respondent number 8.
Respondent number 8.
Respondent number 8 again implemented as respondent number 14. Same person.
Number 8 is Roshanan.
And 14 also same person.
Yes, you noted this. This is matter tomorrow. You just find out. Your same person will delete this and then we'll include the new respondent as for number 14. Yes, this is matter tomorrow. Yes, to enable the counsel for the applicant / petitioner to obtain instructions.
Item number 4.
Please. My lord, I think
Yes.
item number 4 state is yet to file the affidavit, my lord.
Who's to file affidavit?
State
You're not
is-
appearing here, Mr. Debnath.
This in item number 4, I think I'm the respondent of 1. So I don't have any role in this.
Number 1 for?
Union of India.
Lordship, on the last occasion, what had happened, kindly see the causes. There are two matters stacked together. 4 and item number 5.
Okay.
This is a private dispute with regard to who should be the authorized recipient of the land acquisition, of the compensation. Now, in
4
item
and
number
5.
4,
One second. Number 4 and 5. Okay. You appeared which number?
Item number 4.
Why you made them a party then, Mr. Nath?
My lord.
If they they're not. Remember,
item number 15, there is a dispute between the respondent number 13 and
15?
item number 4.
No,
In item number 5, there is a dispute between the private respondent number 13 and the petitioner. The respondent number 13 has filed a writ petition.
My lord,
Item number 5. Your Lordship.
my lord, here, my
okay,
lord.
one second. Just come slowly. Now, who are you?
I am the leader of Imam of Law.
Okay. Now, what is your prayer in this petition?
My prayer is that, my lord, there was the installation of the transmission line.
Okay.
Over the right land, over the land under the jurisdiction of Imam of Law. So there had been some compensation which were supposed to be handed over to the HIMA, being a right land authority. It was not given to the HIMA. No compensation has.
That's your prayer here.
That is my prayer that the authority.
The amount's already been disbursed.
Disbursed.
Okay.
My lord,
Now
as
your
per-
prayer is for pass order upon release.
As per the respondent, it is
the
disbursed.
chief pass an order enforcing the right petitioner. Okay. Pass an order directing the respondents to pay adequate compensation. Okay. That's this number 4.
And also authority also, my lord.
Yes.
The authority of Imam of Law was also not necessary.
And number 5. What do you think, Mr. Sen?
Number
Number 5, Your Lordship, it's fixed for filing of reply.
No. Who are you?
I'm the petitioner number 2 in.
What do you want? Number 5.
In item number 5, Your Lordship, there has been illegality on my removal as a headman.
How is it connected then with the compensation matter?
That is
Yes, Your Lordship. Okay.
I was just coming to that.
Yes.
Just kindly have number 4 as item number 4.
Okay. Number 4. Okay.
No, just kindly have the cost title.
Yes.
The array of parties at page number 5.
Yes.
Kindly see, there is a private respondent arrayed as private respondent number 13.
Okay.
He is the petitioner in item number 5.
Okay.
So he is questioning his illegal removal. Now the petitioner in this case has already pleaded that the entire compensation amount has been disbursed to respondent number 13.
Oh, you have taken the money.
And
I have filed my affidavit, Your Lordship.
Was the money given to you?
Your Lordship, in my affidavit.
No, say yes or no.
In his personal account.
Yes or no?
Yes, Your Lordship.
Then
But
fine. Okay. Yes. Then what else?
So the claim in item number 4 is that the money should be disbursed to the petitioner.
Okay. Number 4. Now, and that's why because of that you remove his headman.
Yes, Your Lordship.
Because you took the money.
Yes.
What's the amount?
I have filed my affidavit, Lordship.
Why do you take the money?
In my affidavit, Lordship.
No, I don't want. Why do you take the money? On what basis?
There's a resolution passed. Because
By whom?
The Robasunong doesn't have
That will
civic
give
involvement.
it to you.
Yes, with due consideration and due understanding of the disbursement authority. We have filed a unanimous decision was taken by the executive committee of the Maungap Klishnong. So
that this land belongs to Maulong, to whom?
Yes,
to you?
it belongs to Maungap Klishnong, not to me as an individual person, but it belongs. It's a village land.
And so that money is shared between you and the Darbar members.
No.
Then
it's more clarified, Your Lordship, in my affidavit.
Okay,
if I may
look at that. This is item number 5, correct? Okay,
no,
yes.
My affidavit, Your Lordship, in item number 4, I have made a clear reply.
Okay. Let's take up number 4 first then.
Indeed, for my lord, I have let the state file the affidavit, my lord, so that the entire procedure, the entire case will come in with a clear picture. Clear picture, my lord.
It validates what they are saying. They are saying that the money has been disbursed to the respondent number 13. We are saying the exact same thing.
No, fine. I mean, on what consideration? Why was it given number 13?
Even
when it was the transmission line went over, what's the amount of compensation?
This amount is about 62,84,000.
Okay.
And
now they say it's over Hima land.
And Your Lordship, I draw your attention.
Historically, is it Hima belongs to this Hima Moplong, or is it belongs to Maungap?
It belongs to Maungap village.
On what basis are you saying that?
Your Lordship, on basis of the document which I have already annexed in my affidavit.
So you were removed by the petitioner number 4. He removed you.
Yes, Your Lordship.
And the Darbar Hima Moplang.
Yes.
Okay. And to the council, where is this figure here? Against the removal, you have to go to Mr. Kinta.
Yes, Your Lordship, we have. But Your Lordship, in item number 5, I draw Your Lordship attention.
Why didn't he? No
Your Lordship,
pass.
Rather than taking up the matter for the removal of the headman, Your Lordship, they indulge even in the land, which they have conducted the spot inquiry.
Indulge in the land, meaning they started
yes,
adjudicating on who's the owner of that land.
Yes, Your Lordship.
That's
Your
good
Lordship,
also.
that is at annexure 21.
And that'll be good. I mean, they will solve the whole issue.
Your Lordship, in accordance with the document which I have relied in my affidavit in item number 4, Lordship, I have given all the clear documents, Your Lordship, related how I have attained the land.
Historically, this is your land only.
Yes, Your Lordship. I have relied on documents which substantiate my ownership.
So your challenge to your removal is coupled with the order of the council, which you say is
yes, Your Lordship.
You have gone beyond the scope of your complaint.
Yes.
Okay. Yes, and you want a reply to be filed by the state. Why?
My lord, that money.
I mean, your dispute is with number 4, right? You have to file another proceeding then.
My lord, respondent number 3 is 13 is a party, my lord, where the petitioner in another case. Now, my lord, entire process was conducted by the state, my lord, through the deputy commissioner and the block development office and other connected offices, my lord.
Now, where's the money? Look, the money's been spent.
That is, my lord, is not.
It's been spent.
Your Lordship, I'll draw your attention to.
No, just one thing: is it been spent or is still there?
No, Your Lordship. A portion of the land, Your Lordship, which.
No, Mr. Dingno, please answer the court.
It has been returned to the rightful owner.
Who's rightful owner?
This Shidalin Pathao. Even the Power also has knowledge of.
Lordship, can I say something?
We have all the documents we have annexed in the.
So you took the money on behalf of this private landowner?
No, Your Lordship. There are a lot of circumstances.
You say that it belongs to the village, the land. You have taken a compensation. Now, why do you go and give this lady?
Your Lordship, let me clear up on that issue, Your Lordship. That they have claim of 2 lines, Your Lordship. There are 2.
Can I say something, Your Lordship?
No, let's see what he has to say first.
For the erection of the tower, Your Lordship, there are two towers that they have claim for. For the tower location, Your Lordship, there are 2 locations for which AP 268 and 269, and AP 269 to AP 270, Your Lordship.
Okay.
That has been clarified, and that is admitted fact also from the part of the petitioner, and even the
admitted fact. Why should he come with a petition to say that you've taken the compensation?
And Your Lordship, I'll draw Your Lordship attention. Portion of this location, later on, it was clarified that it belongs to some private person. And that private person also, Your Lordship, in accordance with this letter issued by the District Council, she was called for this inquiry. Your Lordship?
She's not a party here.
No, Your Lordship. And that money she has accepted, Your Lordship. We have refunded the entire money.
Entire 62 lakhs give to her.
No, Your Lordship. Portion of that.
crore, actually.
Portion of that. Just a portion of the money which belongs to her, Your Lordship. May I refer to the affidavit filed by.
Well, let's hear what Mr. Kanta,
Four and
what
five.
you want to
It's
say.
like my task here is just to enlighten this honorable court. Originally, when the concerned government department, or it's a government undertaking, CREF, they wanted to take a fire line around that area of Mawphlang. Then there was a negotiation or discussion with the Hima Mawphlang. Thereafter, the village of Mongap came into the picture, and finally some compensation was paid, almost running into almost a crore. Then thereafter, the Hima Mawphlang suspended the headman, and now acting is there. Then what happened? They challenged this suspension before the district council. We conducted an inquiry as to how these things has come to about. Your Lordship will be aware that once upon a time there is one Captain Han. He used to have a wine, he used to sell wine, sausages and all those things. And we found out that originally this land belongs to Captain Han. He had given it to his housemate or somebody. Then thereafter it was sold. When it was sold, the original area, which is huge, became constricted by the actions of the headman, village authorities, became constricted. Now we found out that originally this land belongs to Captain Han, then to the person who inherited it. Thereafter it was sold again 2 or 3 times. Then that's how we have conducted an inquiry, and we have not made any final decision. So far, payment being made to a wrong party, according to the writ petition filed by the thing, that in fact the CREF should answer why it was paid to an authority or to a private account of a person. That's the entire issue.
Restriction, regarding suspension, yes. Now regarding the money that has gone for recovery,
No, my lord, there are
based on all disputed facts.
disputed fact.
How will this court sitting here now determine as who's the rightful, who should get the money?
No, my lord, when
This court, you just express will confine ourselves to the legality of the suspension or of the, or examine the order of the district council.
the suspension or removing of the headman, my lord, it occurred after giving all opportunities.
No.
That is legally done. That is legally done, my lord.
Examine it. I'm not saying that we are saying we found it illegal, but I think with regard to this compensation being paid to the wrong person, State, what do you have to say? Nothing.
I would submit this disbursement happened in June 22. This is a matter under section 64 of the PI. I don't think a writ court can suitably answer this issue.
Should answer. No, we can't answer this issue.
My lord, this is the state who has taken the responsibility to disburse the money.
Whatever it is, Mr. Nath, but the basis of this entire controversy is your claim and counterclaim, that's all. Simple as that. And where would you seek remedy? This court sitting won't give you any, we're not an advisory jurisdiction, so we won't advise
I had
you.
advice once.
You know what to do.
My lord, here we have the
You can have everything. You might have all the materials on site, but then this is not the right forum to to agitate for this like wrongful payment or whatever.
My lord, we need a direction, my lord, that the Hima Mawphlang, leader of Hima Mawphlang, is the authority to receive the compensation amount, my lord.
Where's the order of disbursement from your petition?
Disbursement is not clear, my lord. How it was disbursed.
Then where do you say that it's been received? Where have you shown it?
There was
106 of the writ petition.
Well, my lord, there was so many meetings with the authorities, state authorities. State authorities also directed.
106 of their writ petition. Item number 4.
State authorities also directed, my lord, to the concerned person to deposit the money to the.
106.
This is for the first stretch, AP 268 to 269.
Yes. This is a portion of
Fund lease agreement undertaking.
No, the type copy is at 107. This is for the stretch AP 268 to AP 269 for an amount of 62,84,000.
Okay.
This was stretch 269 to AP 270 for an amount of about 24 lakhs.
This is received by respondent number 13, my lord.
13.
Without obtaining any
in respect
NOC.
to page 108, Your Lordship, the money has been returned to the rightful owner.
As per the procedure, my lord, the NOC should have been obtained from the HIMA, my lord.
Now,
those
Your Lordship,
procedures were not followed, and the money has been received.
Yes.
There are certain other parts also, my lord, the compensation has not been paid.
You filed FIR also. Cheating and criminal misappropriation.
We have issued notice also, my lord, 4 notices to appear before the Darbar and clarify the process which has been taken by the respondent number 13. But defying all the notices did not appear, my lord. And thereafter in open village meeting, my lord, in the village, my lord, he was called, my lord, he came and disrupted the meeting. Thereafter, the Mintris and the Darbar was bound to issue the order of removal and appoint an acting Rangbashnang, my lord. After appointing acting Rangbashnang also, my lord, he was keeping all the documents, materials with him and was functioning, my lord.
We take a call. What to do your petition?
Your Lordship, may I?
You take a call. It's like a private dispute. Yes.
I have relied all documents necessary to substantiate my case on whatever the submission made, Lordship, and I've counted again. And a short reply to my submission of the letter, Senior, Your Lordship, is that how I became the landowner, Your Lordship. I have relied on a document which was executed in 1987, Your Lordship. At that point of time, it was still the Maungap, it was just simply Maungap, Your Lordship. And then there was a bifurcation later on, which when I bought the seal deed also, it was still under Maungap Rim, Your Lordship. And then afterwards, this land, after bifurcation and recognition of the present Maungap Kleshnong, Lordship, it fell under my jurisdiction.
I think
so it was noted by this person also.
In fact, the red petition launched by the Sur Upadba is an unregistered organization. And petition...
Sur, what's it called?
Got no legal entity, my lord.
It's not a registered organization.
What was there one?
And the other thing, my lord, the aggrieved ex-Rangbashnang, my lord, has never approached by himself against his removal either before the district council or anywhere.
That doesn't matter. Yes, sir. What should we do, number 4? Should we continue with it or should we dispose it of?
Well, let them file the...
Why? What purpose?
My lord, I'll substantiate my point, my lord, after receiving the...
I'll file it within 2 weeks.
Yes, though the matter appears to be between private parties with the disbursement, with the receipt of compensation of land acquired for erection of towers by the respondent number 3, number 4 and 5. Mr. Echarnath raised that some examination be done by this court after the affidavit from the respondent number
2, 7, 9 and 10.
2, 7, 9 and 10 is received. Though this court has reservations about continuing with the incident petition, let the affidavit be filed within a period of
2 weeks more.
2 weeks, list thereafter. Yes. And so and so. Yes. Number 5.
That can be closed, Your Lordship.
Number 5, my lord.
It can be closed and remanded back.
No, the second one.
Yes.
Second, we'll close it?
No, Your Lordship.
Why?
Because the removal was not made in accordance with this council.
There's a judgment of this then High Court, Meghalaya Wine Dealers Association, which says that an unregistered organization cannot launch a writ petition.
100 decisions.
Yes, Your Lordship. It can be closed and we'll
No, Your
take care.
Lordship, let me substantiate.
Yes.
Give more points, Lordship, on that. At first instance, Lordship, when I moved this application as well, Lordship has put that question as such. And they may be strike off.
I said, who is this Sur Kinong Shong Shnong?
Yes, they are represented by the people.
Kinong.
Your Lordship, when the headman was removed, Your Lordship, by the respondent number 1, Your Lordship. So they were left just like that, Your Lordship.
There's no like that meaning?
Nobody was taking charge as a headman, Your Lordship. And then at that point of time, he made the removal in accordance his own.
Let's see, removal order.
There's no removal order, Your Lordship.
Where is the order of suspension then?
Order of suspension, it came directly by that impugn announcement which I've made, Your Lordship, for stay.
Page? Page?
Like an array, or like that. 37, Your Lordship.
37.
It was just by announcement, Your Lordship, that he was removed. And immediately upon the announcement, Your Lordship, the
then where's the order of the District Council?
There's no order of the District Council.
There is no order, my lord.
It's still pending, Your Lordship. We have
just conducting inquiry.
My lord, what happened, my lord?
So where's your petition for the District Council?
Your Lordship.
Where's the petition you filed for the District Council?
That is still pending.
That is also.
We'll close it, Mr. Lingdo.
No, Your Lordship. Then
Why
there
no,
will
no?
be chaos and chaos.
It's up to the court
Your Lordship,
to see whether
then, Your Lordship, the petition number 1 will be strike off, Your Lordship. Then I'll pursue with the petition number 2.
Where's your petition before
Where's your
the
petition?
council? Your appeal.
We do not even annex it here.
Where's the appeal petition for the council?
It was filed by the petition number 1.
Where is it?
Page 46, Your Lordship. 47 is the type copy.
It was not filed by the aggrieved person who was suspended.
Yes.
Why?
It was filed by some other people.
How will it be sustained then?
Your Lordship, let me take instruction on this, Your Lordship.
This one you have to draw it then, Mr. Lingdo.
Like
It's
this court for
really
too long.
how big? Yes, sir. Mr.
No, Your Lordship, even if it will be disposed, Your Lordship, then there will be unabated interference, Your Lordship, by the...
If you dispose it, it will give you liberty. You can approach the council afresh, or you can whatever liberty you want. Because as it is now, this petition is not maintainable.
It's under Act of 59
Even
also.
the appeal, if it is the council, is by some other entity. It's not by the aggrieved person.
Yes.
Yes, Your Lordship, but the suspension, even in the removal of...
Tomorrow. This matter tomorrow to enable the council petition to obtain instructions. You know the tentative view of this court. Even yours, Mr. Nat will go.
Well, let us.
Lordship, let it come on Friday.
Okay, Friday. Yes. Mr. Kantai be here. Yes.
15.
Item number 6.
16.
Oblige.
Oblige.
16. Oh.
Any instruction, Mr. Day?
Yes, my lord. He has not been removed yet.
That is what? Where's the lawyer? Or where's the council petitioner?
We have received Parawai's command also. We would like to file a small affidavit also.
Affidavit for what? Is it, from which post?
Gaubura.
Gaubura.
Yes. Time may be given, we'll just file a small affidavit.
None appears for the petitioner. This is a matter for 2 weeks. Mr. S.D. Praise was allowed to file a short affidavit in the meanwhile. That will be is for dismissal. You can't file. No cause of action has arisen. Yes.
My lord, so far as the state is concerned, we have already filed our affidavit.
You are appearing for?
I'm appearing for Respondent 6, my lord. I'm filing my counter affidavit today.
R6. And you?
Appearing for Respondent number 5.
Number 5.
Yeah, file our affidavit.
You file?
Yes,
You're Rapsang, no?
Yes.
5. And Arwan Lang?
I'm for 2 and 3. I'm praying for 1 week's then.
You're not filing affidavits. Why? Too busy with other things.
Instructions are awaited from the commission, Your Lordship.
Yes, okay. You already filed it.
Yes, my lord.
You're for number 1.
1 and 4.
1 and 4. Take down Mr. Pasat 1 and 4. Submits that it's already been filed. MS B. Karan now for 2 and 3. Please that 1 week's further time be given for filing affidavit. You file in the course of the day.
Yes,
MS
it's ready,
O Bank. Order number 6 submits that it actually filed in the course of the day. And you also filed. Now, top and commission. Ms. A. Pasat 1 to 4 and B. Rapsang was number 5. Submits after it has been filed. Then after that 2 and 3, it is 1 week's time. And 6 has in the course of the day. List a matter after 2 weeks. Yes.
My lord, 7 and 8 are connected matters. 7 and
7 and 8. The same respondents.
Same respondents.
Numerically. Okay. Yes. So
Much
it is in order.
Your Lordship.
9.
Please, Your Lordship.
My lord, I have received the copy of the rejoinder affidavit, my lord, just yesterday.
You have received your GCBs?
We have received.
Then?
We have received, my lord.
So you want to close the matter or you want to pursue?
Lordship, actually the matter can be closed. I was just talking to my friend also because our limited challenge in this writ petition was...
And then you have recourse to other remedy if necessary.
Lordship, so what I was mentioning is that because our only challenge was that he, respondent number 2, the local administration do not have the authority to act against me under the rules. That was my only point of contention. In their affidavit, in black and white, they have admitted that yes, they are not the competent authority. Matter ends there, my lord. Matter ends there.
The general submits that pursuant to the order dated 2012-2023, nothing substantial remains for consideration in the present writ petition. He prays the same will be closed. Yes, liberty to pursue other.
No, no, my lord.
We close?
No, my lord. Because there is a verbal order still standing as on date against us.
It will be closed. No, since it's been verbal order is not here. I mean, we are just we can't.
Lordship may kindly observe that we are at Lordship. May kindly observe that Lordship, we are at liberty to conduct our work, my lord, as in accordance with law.
Yes, of course. Problem. Well, 20?
12.
2023. Yes. And that he be allowed to continue his work in accordance with law. Seem not objected to, Ms. Ensign. Matter stands closed. Yes. And disposed of.
Obliged. Highly obliged.
10.
Yes, Mr. Pathak. Yes.
Your Lordship, we've received instructions.
Then, item number 10, my lord, instructions were sought for, my lord. This is relating to a simple issue relating to non-registration of an FIR. The issue was, my lord, relating to non-registration of an FIR.
Your Lordship, we've received instructions.
What instructions?
And the FIR has been registered, Your Lordship, and investigation
Instructions
is
were
ongoing.
sought for, my lord.
Let us see. He said that the FIR has been registered.
Investigation is ongoing, Your
And
Lordship.
investigation is underway. Have you, let's see, who's the local counsel? Mr. Pathak. Mr. Pathak, who's the local counsel here? Anyone? He can't hear me. Your local counsel?
Yes, Your Honor.
You give a copy of this to show to Mr. Pathak. Yes, MS Zedi Naukri today has produced a set of instructions dated 3rd February 2024 indicating that an FIR has since been registered and a non-FIR case has been sent to the court. It's under section 107/148 ZPC. The council to take instructions. This is the matter day after tomorrow. Okay?
Authorised, Your Lordship.
I know.
Eleven.
Please, Your Lordships. This is a matter we'll recall. We moved it unlisted, Your Lordship, where, my Lord, the enforcement staff was withdrawn, Your Lordship, without
Yes.
any notice, in spite of an order of status quo by this court. The original impugn order was withdrawn. And thereafter, my Lord, we are under expectation now we would run it till next year, my Lord, because the impugn order was withdrawn, my Lord. Earlier writ petition filed virtually became infractuous. Under this expectation, my Lord, on 1st February, what they did suddenly, my Lord, without notice, without anything, my Lord, the enforcement staff was withdrawn. This was a way breach come check gate, Your Lordship. Now, what happened? The government deputed the enforcement officers there. My Lord, they cross-checks, verify, countersign, and then how it is operates. Now, without them, it cannot be. So, virtually, they have shut down. So, that was my grievance, my Lord, and I sought for a, my Lord, interim protection to restore the enforcement. Now, Lordship, my Lord, considering, my Lord, that some instruction is required, and directed that the matter would come up after a week. But unfortunately, my Lord, it's never listed after 1 week. Today, almost after, my Lord.
Why is it listed for 1 week?
Almost after, my Lord, I think 11, 12 days, matter has come up.
Yeah.
My Lord, there is a great sense of urgency, Your Lordship. At least,
What's
Your Lordship.
happened now? Enforcement is not there, you can't do
No,
anything.
my Lord, we cannot run because this all depends on the enforcement.
Yes,
in spite of a court order, my Lord.
That order has been withdrawn. That order has been.
The earlier case, yes.
So that order has. So, my Lord, so far as the fresh writ petition is concerned, my Lord, I am instructed to say that that order which was there, which has been withdrawn, my Lord. Main matter, my Lord, is the 13, item 13, where the issue is, my Lord, that there is no lease agreement by the government.
No, what about enforcement?
So we have withdrawn that. We have.
No, you withdrawn enforcement also, you withdrawn the order also.
Earlier,
No, see, it's not that. The earlier writ petition, you see, why you've withdrawn the
That we have instructed the department not
the
to.
order of non-extension of his lease has been withdrawn.
Non-extension of the lease. That order has been withdrawn, my Lord. That is at page.
So that withdrawn now. It's withdrawn, so he was in, to operate. I mean, if
Yes, Your Lordship will. Of that order is at page 76, my Lord.
well, we are aware because this matter was heard last time.
Yes, my Lord. So main matter, my Lord, is because he has no
That
right.
matter's gone now. This becomes the main matter. Now his grievance there is that you
My Lord,
you give it one hand and taken away with that.
No, my Lord. In the main matter is, my Lord, what if I summarize, my Lord, what has happened, my Lord, that he was having lease for period of 3 years from 2017.
Correct.
Two
Now,
and three.
just listen to the court 1 second, 1
Yes.
minute. Now, lease was having 2017, there was COVID, so on and so forth, and it come for this court. Court said to examine, but the respondents gave an order that as pursuant or as per the order, extension be given, which was never directed by this
Yes,
court.
Lordship.
Now, this court had noted that and
Yes,
said
Lordship.
that, you
I wanted
and
to
what
add
was
one
the
more
paper,
point.
Listen, what is the paper trail, how that order came to be about. Now, the order's production of the documents to show how that extension order was given, when there
Yes.
was no
Yes.
direction from the court.
Yes, yes.
Now, to avoid that, the whole thing was withdrawn because the records want to be produced. Now
The
you
record we
withdrew it,
have.
and withdrew it, and cleverly now to somehow frustrate the entire thing.
No, my Lord.
Yes.
I'm sorry because that's
It's just
the.
from facade. I mean, on the face of the record.
I will clear the confusion, my
I
Lord.
don't think you can clear it.
Hopefully, I will endeavor.
Let's
my
go
Lord.
to other petition first.
I mean,
Then
yeah,
we'll
Lordship.
come to this.
Yes, Lord.
There's
Kindly
item
see.
number 14.
13.
Yes. Now let's
Yes.
see the order withdrawal. Where's that?
Just so many other withdrawal.
There is 76.
In your affidavit.
Fresh writ petition, Lordship.
No.
Old, 76.
76, my Lord.
Page 76.
That is 299/2023, Lordship. 76.
That was my grievance. I challenged this. I challenge this. Lordship will recall, my lord. That matter after initially Lordship was not inclined. Detailed hearing, my lord. After detailed hearing, your Lordship has granted me a stay order.
Lordship,
that was extended. And the last occasion, your Lordship, what your Lordship has directed. You'll ask me. Let me submit. I know my case.
Yes.
Now what your Lordship?
You don't know your case. Let's see the order you challenge first.
Now, my lord, what happened? Lordship had extended the stay order. Matter was supposed to be listed on 29 January, your Lordships. Now, during the vacation, what it mentioned that in pursuant to the order of this Honourable Court, these latter 76, which was under challenge, my lord, in the writ petition, that has been withdrawn. So, matter ends there, your Lordships. Nothing.
Let's see the last order where we withdrew this impugn order.
Their order.
See, their order whereby
Lordship.
They withdrew this 10/8/23.
This one 96? 96, your Lordship. Page 96 of the fresh writ petition.
Oh, it's not here in the old writ petition.
No, right? This is in the fresh writ petition.
Okay, yes.
Page 96.
Yes, you see, this come to page 76 of the old writ petition, next year 13.
Lordship.
Okay, it was extended only up to 26/23. You came to court, correct?
Yes, my contention was as per this.
Okay, fine.
28.
That is supposed to run to 25.
Lordship.
Now in the new writ petition,
Lordship.
With which page is the?
Page 96, Annexure 20. May I read it, my lord? Dated 16 January 24.
See 96 again. See this one, Mr. RP General.
Yes, Lord. I got it.
I'm
Yes.
so.
This is 96.
Withdrawn.
Withdrawn.
So why you withdrew it? Why didn't you go ahead with the matter?
Yes, my lord. I will explain.
Now you can't continue the hearing of this case because you withdrawn it. The whole cause of action for this one.
No, if your lordship kindly see the prayer in the writ petition. Kindly see the prayer in the writ petition. In the old one, your lordship. No, 24. Kindly
Old one or
see
new one?
Old one, my lord. Because the old one is the basis of his right, my lord.
The old one's gone now.
Now your lordship, prayer 4, my lord. Direct the state respondent to act in accordance with renewal agreement dated 1/6, page 26.
Yes.
To direct the state respondent to act in accordance with renewal agreement dated 1st June 2022 and to comply with the order dated 16 passed by the state respondent. So the whole case of the petitioner, my lord, is based on this agreement only.
Where are you reading from?
Page 26, small Roman 4, my lord.
26?
Sorry, this is 20. Old.
Old petition. This is 299.
299. Yes, sorry. Yes. There are so many. Now your lordship will see the prayers because their case is based on this agreement only. Impugn letter dated 14 July issued by page 19 by the Commissioner of Transport intimating the writ petition that agreement for operation of way bridge extended up to 30th September 23 as convened by the government. Prayer number 2, impugn letter dated 1st August 2023 issued by Commissioner of Transport addressed to the writ petition returning the original copy of challan at Amsrin on the ground that government has conveyed the approval for extension of agreement up to 30th 9 2023 as illegal and unconstitutional.
Yes.
Impugn letter dated 14 July 23 issued by Commissioner of Transport intimating the writ petition that agreement for operation of up to 30th September as convened by the government. Impugn letter dated 1 issued by Commissioner of Transport addressed to returning the original copy of the challan on the ground that government has conveyed the approval null and void, my lord. As per the agreement dated 1/6 bottom, my lord, and pass such order. So the basis of the case is that there is an agreement with the Commissioner of Transport. That agreement is valid for a period of 3 years, so they are entitled to run the way bridge for a period of 3 years. That is the case in the old one, my lord. What the stand of the government before your lordship is that this agreement was not approved by the government, which is requirement of law, and therefore the way bridge which is being operated under the agreement with the Commissioner of Transport is contrary to the statutory rules. That is
okay. Okay, let me intervene. Let me just interrupt you there.
Yes, Lord.
Now, well and good. Now, when this matter came, well and good, impugn order was there, run to so and so, that is being contested.
Yes, Lord.
And while hearing, like because of the fact, okay, status quo to be maintained.
Yes.
Now, court had asked you to produce. How was it extended?
No, that
how
file
was the new agreements entered into?
That file
That is
we
what.
have.
That is what.
That file we
so,
have.
so court inquired, and what did the government do? They withdrew the entire impugn order.
You know,
that means implying that you carry on.
Understand? This is stupidity, I can say, because
Yes.
I don't know, they are trying to favor whom. But if we
No, listen. So after that, now they said, okay, fine. Withdraw the order. So it means this whole matter becomes infructuous because impugn order is gone. The course of action is gone. Then you come with a new tactic that he's saying that you remove the personnel from the weighbridge. Stupid over smart.
they have to go by whatever is law is
exactly.
That they are, unfortunately, sometimes, my lord, I am also helpless in their hand.
I can understand a position, totally.
They do not know right hand is doing what is left hand is doing. That, my lord, what I was praying, my lord, that the main issue is whichever
main issue is dead.
Main issue is my friend has filed saying that in 24. What my friend has said, if your lordship see the prayer, that he says that the agreement of 22 is valid, my lord.
It is valid because you withdrawn an impugn letter.
So impugn letter, which was with respect to
extension
giving
up to
3 months only, my lord.
That's gone.
That's gone. So now he says that you, in terms of the agreement, extend my right.
No, it doesn't need to extend it because the agreement comes alive.
Your lordship, kindly agreement, and what I say is that there is no. What my friend is praying, my lord, kindly see the page 24
of the new writ petition.
New writ petition.
Okay. So we'll close the oral petition first.
Yes.
We'll close it.
Your lordship, here the both matters together, my lord. Your lordship, here the both matters because replies and everything is there, my lordship. Kindly see page 26. Small Roman 4.
Page 26.
Yes. Small Roman 4, my lord. To direct the state respondent to act in accordance with the renewal agreement dated 1st June and to comply with the order dated 16/1/2000 passed by the state respondent. So the whole fulcrum of the case of the petitioner before your lordship is that this agreement of 1st June 22 is a valid piece of agreement and right accrues to the petitioner based on 1st June 2022, my lord. Now the issue which falls for your lordship's determination is whether for state is contesting that this agreement is not valid, it is not in accordance with the statute, and therefore no right flows in favor of the petitioner. That is the case of the state. My friend's case is that, so my lord, I have to show whether any right flows from this agreement or not. If I demonstrate before your lordship that no right accrues in favor of the petitioner, I will succeed. If my friend shows that right flows from the agreement, my friend will succeed, my lord. So the list between the parties is this, whether this agreement could give any right to the petitioner or not. My humble submission, my lord, is kindly see the statutory rules in this regard, my lord. And those rules are already on record, my lord, in the writ petition at page 29.
For a second, your lordship. Now, today, my lord, the matter has come up because the old writ petition has become infructuous moment they say they had withdrawn the impugn order, your lordships. That became infructuous. Now, I file a fresh writ petition. Obviously, I admit, my lord was wanted to examine, my lord, the validity of the extension. That was pending, but they had withdrawn the impugn order. So the original, my lord, the renewal agreement came into life. Now I am aggrieved by your lordship, sudden, without notice, withdrawing the enforcement, virtually closing down my weighbridge. Immediately I came, first they have withdrawn, second I moved it unlisted. I prayed for an interim order. Now, in this case also, definitely your lordship will go and examine, my lord, whether that renewal agreement was properly done or not. Lordship in a first case, let me.
There is a prima facie case or not?
Lordship will, my lord, lordship has in fact in the last case called for the records also. I don't know why they are shying away from producing the records. Now there is no question of producing record in the case which has become infructuous. Now these issue again your lordship will examine, no problem, my lord. They will file affidavit. Lordship will examine, look into the records. In the meantime, what happened? Lordship had protected me. They had withdrawn it. Lordship, give me the interim protection. Ask them to restore the enforcement. Why they are playing like this? They are not only, my lord, infringing my right, they are slighting the order of this court.
No, we understand totally, Mr. Sen.
So, my lord, my question, my lord, today your lordship will consider direct
the court now is like, what instructions did you have?
My lord,
after it was moved last time.
My lord,
why was the enforcement removed?
My lord, the issue was.
What was the necessity?
Yes, your lordship. That I have to explain, my lord. That
yes.
I have to.
That explain why.
That, my lord, his whole case was against that very particular order, by which the challans were not accepted and then your lordship passed the order of status quo. That order was passed by the parties to maintain status quo with regard to his right to run. Now what he is saying that I have a right to run and I have a right on your staff also. And I have got, my lord, within vicinity of 2 kilometers, I have got my own government department weighbridge running. My lord, how many trucks, same truck will go to his weighbridge, they will fleece him there. In my government run department, I have a right to run, my lord. Government is the government. The Act statutory provision says so, my lord. So therefore, first he has to demonstrate that he has right to run the weighbridge, my lord. If he has colluded with my official and he has not approved the government approval, my lord, it is in the public interest that departmental, and we have got the, if my friends can deny that departmental weighbridge is running nearby or not. There is a departmental weighbridge which is running next to his weighbridge. So this is, so therefore ultimately your lordship will weigh whether there is a case of
how long ago did the department of weighbridge been established recently?
It is there in within.
It's just been made.
It is there, my lord, running.
From before?
Before, my lord.
Then what? Then
there should not have been. That is what we are saying. That is what I am saying, my lord. There is a 2017 agreement. Auction was there.
Listen, then why did you withdraw the order then, or the impugn order?
The impugn order.
If you're standing so steadfast on the rights of the respondent.
Under the mistaken bona fide mistake, my lord, this is a mistake on the department, I must admit.
Why did you withdraw it?
They should have not withdrawn the order, but because they thought that now we have got departmental weighbridge.
No, where's the justification?
There is, my lord, there is no justification. I admit, my lord, there is absolutely no justification because in law.
Behest of some X, Y, or Z.
There are problems, my lord. I know that what sometimes we have to cut sorry figures here. But in law, my lord, kindly see who is scrupulous, who is unscrupulous. He is blaming the government that we have been. But ultimately, if your lordship will appreciate that this person who has no right to run the weighbridge, and merely on the basis of the agreement, which is not the agreement in law, my lord, he...
Correct. The court is examining
that. And the court was examining,
yes,
Lord.
That's what we asked for the records. You see the order did 812.
Yes, Lord. I've argued also. Your lordship was very keen that how this
Let us see, where's the paper trail?
Yes,
and if the court interfere, if it's found that it's found on any basis, and because it is a misinterpretation, or that's why, like Mr. Sen said, the majesty of this court, it applies otherwise also. The majesty of the court, we never directed, the court never directed for renewal. How was it done?
This was,
and why was it taken the shelter of the court? And again the status quo. So why, again the status quo has been ordered to look into all these things. Again, another things been done.
Yes, your lordship.
By the same respondent.
Yes, your lordship. Your lordship is absolutely right. I have no defense where, so far as government action is concerned, I have certainly no defense to. But your lordship will take a larger view. What I say is that I can't.
So on what premise will we argue this matter then?
No, I will argue on the basis, my lord. I will argue on the basis that the petitioner has no right to continue with the weighbridge. If he has no right to continue with the weighbridge, he can't insist and say that government should continue to provide the officials from transport department, police department at his weighbridge. First, he has to establish the right, my lord. I put a question to myself whether he has a right. Because your lordship has seen the manner in which the agreement was signed by the Commissioner of Transport, who is not the authority under the rules, my lord. Who has no authority under the rules to sign it. And it is in the teeth of statute.
You drop proceedings against that officer?
Yes, your lordship recommend, we have transferred him, but your lordship, here I understand, my lord, this requires stern action on the part of the government. We have transferred the officer. But on the face of it, my lord, officers will face whatever. On the face of it, whether my friend has a right to run the weighbridge. If he has no right to run the weighbridge, he has no right to ask for the government staff to support his running of his weighbridge. When we have the weighbridge, and your lordship is aware of the problem in Meghalaya when we have so many weighbridges and they are not in the name of weighbridges, they are doing all kind of things which I can't spell. So, my lord, I have been lawyer that side, my lord. My order has been relied when I was in Supreme Court. 2015 order, I was there, I got this. Those orders are being relied. But I have seen the state very closely, my lord. Now I realize that there is no right. And if I can show 2-3 statutory provisions, my lord.
My lord, if I can submit, my lord. Today we are on the interim application.
So I am arguing on interim only. I am saying that there is no right.
No, I understand what he is saying time and again is repeating, my lord. What is he repeating?
I am not
Whether
repeating
that
anything.
agreement, extension agreement, correctly done or not. These lordship.
You start. You place your case with regard to this ED, like how it affects.
My lord, I am just on interim today.
Yes.
Interim.
We'll reply. Where's the interim prayer?
Interim application. I will take my lord to the extension agreement, your lordships.
What is the prayer?
Prayer is, my lord, to restore the enforcement.
There's a final prayer.
No, my lord, interim also.
Declaring the drawn posting staff person has been constitutional.
6. Interim application.
25.
Interim. 6. Page 6. Well, that is what I am praying, my lord.
You have miscase, you filed a miscase.
Yes, I have filed a miscase, your lordship. Now, my lord, if I can take, my lord, to the writ petition, my lord, I will not, my lord, repeat all those things which I have stated, my lord, in earlier proceedings.
Yes.
Now, admittedly, my lord, pursuant to the rule, they have a Weybridge rule of 2010, your lordships. Settlement was made in my favor by inviting tender, 2017. 2017, my lord. That is not in dispute. By inviting tender, I being found the most suitable tender, it was settled with me.
That was in which year?
2000, my lord. These I have annexed, your lordship, at page, my lord, 39. Page 39, annexure 5. This agreement was entered into on 7th day of December 2017. 7th day of December 2017, my lord. Your lordship.
So the first agreement for 3 years.
For 3 years. Now, thereafter, your lordship, what happened? The government, the transport department issued a notifications, my lord, declaring which are the Weybridge entitled, my lord, to do the checking, and which are the only Weybridge and which are Weybridge come checkpoints, your lordship. If your lordship comes to page 49, annexure 6. Now, my lord will come to serial number 2.
Okay.
Amsarin, that is my Weybridge. The checkpoint
Where
come
is it located?
Weybridge, Garampani, etc. Now, lordship will see in this stretch, West Jaintia Hills, there is no mentioning of any government Weybridge. Now, my learned friend saying it is already existing. That is a blatant lie before this court.
Okay. Does not go there. Don't get
Lordship.
this is fine.
So,
Just
this was
argue
the
with
only
me.
Weybridge, my lord, which was recognized
Yes.
as Weybridge come, your lordship. This is very important. Weybridge come checkpoint.
Okay.
Now, what is the meaning of this Weybridge come checkpoint, your lordships? Now, what happened, your lordships? When this was expired, my lord, that COVID came. Things were not functioning at all. I have applied.
Expired on?
These, my lord, normally expires, my lord, 5 years expires.
5 years or 3 years?
3 years, your lordship. 2020, your lordships.
Up to 6 December, yes, okay.
6 December 2020. Now, thereafter, my lord, admittedly, government made, my lord, some interim arrangements. Some extension was done. And for some period, my lord, nothing was functioning because of the COVID-induced lockdown. It was not functioning at all. But I formally, as required under the agreement, I formally filed a renewal applications. Now, there contain a, my lord, the clause contained as well as the rule contains, my lord, a provision for renewal. I filed a renewal applications. But since they were not taking any call on these, your lordship, ultimately me, along with some other similarly situated person, my lord, approached this honorable court and filed a writ petitions for a direction, my lord, to consider our case. Now, in the writ petition, my lord, Transport Department, not only the Commissioner, the Secretary, that affidavit was signed by the Secretary also, filed an affidavit before the courts saying that we are favorably considering their petition for renewal. We will look into the records and we will do the needful. Now, my lord, this honorable court, where is that? Court's order, my lord. Court's order. Court's order, first round of litigation.
Page
93, madam. If I can just
59,
please.
annexure 9.
93, annexure 80. The matter was heard at length, but however the same could not be concluded. It is The petitioner who, no, sorry, my lord, I'm just...
See page 40, that's what I'm saying, page 59, section 9.
Sorry, I'm not. Page 59, my lord.
Yes.
Page 59, your lordship. This batch of writ petition has been filed for renewal and continuation of the existing agreement between the state and the petitioner for running the weighbridge. It appears that the petitioner are still running the weighbridge, and as per the affidavit of the state respondent as indicated in paragraph 5, the renewal of the petitioner license will be considered in the event that an appropriate application is submitted before the state respondent. But here, my lord, I'll just stop for a while. In fact, somehow, my lord, it's missed the attention of this court, and I don't know. Petition was already pending before the authority renewal application, your lordship. But even then, there was some kind of direction, my lord, that there will be a fresh petitions. In view of the circumstances, the affidavits please, Mr. Sangleshu, counsel for the petitioner submits that the writ petition can be closed. Accordingly, it is directed that the writ petitioner to approach the state respondent with an appropriate application within a week, which is to be considered expeditiously, preferably within a period of 1 month from the date of receipt of certified copy of this order. With the above direction and disposal. So that was the direction of this honorable court. Lordship, kindly come to the next order, my lord.
Yes.
That is page 61, Annexure 10, dated 30th May 2022. The Honorable High Court of Meghalaya, while passing judgment in WPC number 1, such and such, dated 9/5/22, has directed the petitioner to approach the state respondents, that is the Transport Department, with an appropriate application within a week, which is to be considered expeditiously, preferably with a period of 1 month from the date of receipt of the certified copy of its order. The Office of the Commissioner of Transport, Shillong, thereafter received the copy from the petitioner on 11/5/2022, which has been processed, forwarded, Lordship will take note, forwarded where? In original to the Transport Department. On 11/2020, wide letter number dated such and such, 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 as directed by the Honorable Court. Now here, my lord, if your lordship recall, my lord, I made a prayer, my lord, these are the relevant files lordship will need to look into.
You called for this file?
And lordship had called for. And after this, my lord, why this action I could not understand. Therefore, in order to comply to the direction contained in the Honorable High Court order, hereby directed to pay the renewal fee of 250 by Treasury Challan number such as to ensure enable the signing of the agreement in respect of the such and such, such and such. There are 3 weighbridges, my lord, 3 writ petitions verified, sent to the department. There were reference of some reports. We do not know. Lordship has called for. When the situation was pending at this, they had withdrawn the impugned order.
Yes.
I don't know what rattled them. Something has rattled them.
Yes. We will ask for the production.
Now, my lord, next page, the renewal agreement. Now, these entered into on 1st day of June 2022. Now, my lord, I will particularly, my lord, rely on 74. Now, this is again, I am saying, my lord, weighbridge come check gate. Notified with. Lordship will come to page 74. Why, my lord, without enforcement, it cannot be functional. Clause 19.
Yes.
The licensee shall issue receipt of payment fee to each good-laden vehicle signed by the driver, licensee, and duly countersigned and sealed by the enforcement inspector, assistant enforcement inspector. The printed copy of the cash receipt of the payment certificate shall be submitted to the Office of the Commissioner, Transport, Shillong. So, my lord, these cannot be functional without the enforcement being posted there. This is just not a weighbridge. Weighbridge, calm checkpoint. Now, this is clear, categorical, my lord, in the renewal agreements. So, my lord, if enforcement are not posted there, it amounts to closing down the weighbridge. Thereafter, your lordships, my lord, at page 76, 76 or 96? 96, that. Thereafter, your lordships, when I was making my payments in time, I received a letter, my lord, 85/14. Annexure 14, my lord, dated 14 July 2023. Subject renewal license. You are hereby informed that the agreement for, now again they use the word agreement, my lord, there's all kind of confusion. Agreement means that agreement, my lord, last agreement in 2022, which was for 5 years, 3 years. Agreement for operation of the weighbridge is extended up to 39/23. as conveyed by the government in their letter, such and such, such and such. Now, here, my lord, I was aggrieved by this.
Yes.
But even then, my lord, orally I approached them. I tried to convince them these exist, tried to tender the amount of money. They returned the treasury challan. Those also I have annexed. Now, my lord, being without any option, I approached before this honorable court. Now, this honorable court at the initial stage, my lord, given sufficient time to the government to obtain instruction and declined to give me any interim protection. And thereafter, this matter was heard at length. At one point, your lordship posted the matter for final disposal. An elaborate submission was made by the petitioner. Detailed submission was made by the Advocate General. My lord, after looking into the, my lord's, after hearing in details your lordship took a view that this matter needs further consideration. There are serious things involved. So lordship had granted me interim protection of status quo with regard to the operation of the weighbridge. Now, this order has been extended from time to time. And on the last occasion, my lord, this one, which one, page? Last order, my lord, passed in the earlier writ petition is at page 95.
Yeah.
Now, that is dated 8/12/2023. In the course of hearing, it is seen that the communication letter referred to in order dated 30th May 22, appended at Annexion 9 to the writ petition are necessary for proper adjudication of the matter. The records are necessary as prima facie it appears that the order of this court dated such as have been misinterpreted and misconstrued. Accordingly, lease the matter on reopening of the court on 29 January 2024 for further hearing and production of records. Interim order shall continue until next date. The original interim order also I can read, your lordship. This is there. What is that? Original?
No need.
Anyway, that is with regard to, my lord. This. I was running it. Now, my lord, came the vacation. Now, during vacation, my lord, next page 96, my lord. Dated Shillong, the 16th January 2024. Renewal of license of weighbridge at Amsarin, such and such. With reference to the, my lord, you will see reference. They have referred to the impugn order, which I have challenged in the earlier proceeding, 14/7/23, which was under challenge. Then they are saying, with reference to the subject and order number cited above, I am to inform you that in view of the Honorable High Court of Meghalaya, order dated 8/12/23 in WPC number 299 of 23, the order dated 14/7/23 referred to above is hereby withdrawn. Now, what is this? My lord, is it so difficult to understand? Impugn order has been withdrawn. And if the impugn order has been withdrawn, my lord, the original renewal agreement revives. I continue. That is altogether, my learned friend is saying time and again, by virtue of this, that was done unauthorizedly. That was a matter under consideration of this honorable court. Lordship wanted to examine. Lordship had called for the records. Now, by withdrawing this, they had revived the renewal agreement. I was entitled to continue, my lord, till next year. Now, my lord, thereafter, this happened, your lordship, 16 January 24.
Yes.
Now, my lord, court reopens on 29th. But somehow this matter was not listed. I was, my lord, I had in my mind to inform the court the matter had become infructuous. 29th, since your lordship was not sitting, perhaps it was not listed. So anyway, since it was withdrawn, my lord, otherwise there would have been a question of extending the interim order. So I did not make any endeavor to get it listed and get it extended. Obviously, when no lawyer would do that. Now on fast, my lord, I took the rudest shock. I was running it smoothly. Suddenly, without any notice, without anything, my lord, what they did, they had withdrawn, without any formal order, withdrawn all the enforcement stuff.
Yes.
And set up a weighbridge, my lord, just 2 kilometers away. My learned friend is saying that government weighbridge was always existing. I had taken your lordship to that notification. There was no government weighbridge in 2018. This was, my lord, very recently, my lord, just only with an intention to deprive me. They have relocated them to an weighbridge just 2 kilometers away. Only intention somehow to close down. Now, my lord, lordship, just as a matter of evidence, they started, this government weighbridge started issuing, my lord, after relocation of this enforcement stuff, they started issuing, my lord, the weighment slip. Now, first weighment slip, my lord, only dated 1st February, I have annexed at page 97. Type copy is next page. Type copy is next page.
Only.
I'm sorry. Amjahar is just 2 kilometers. This is the vicinity. This whole Malafide intention, my lord, somehow, my lord, to shut out my thing.
This is Weybridge.
97, my lord, type copy is a 98.
Women's slip.
Lordship. Amja Weybridge. That's just 2 kilometers away.
Amjeha. Now all the trucks are being there.
Yes. So, my lord, this is my submission, your lordship. So unfair, so arbitrary, my lord, when the proceeding was pending before the court, your lordship, and lordship had called for the records. Perhaps everything would have come out from there. And lordship by this time could have finally decided the matter. Could have been in their favor also, my lord. They had withdrawn. Now they had withdrawn the staff also. Now what are the consequences of this thing? Shutting down my Weybridge. My humble submission, my lord, at this stage, your lordship, because this need to be examined, lordship need to look into the records. Now I have raised these additional points. Now, my lord, government need to answer it. As of now, my lord, I will seek an interim protection, your lordships, to direct the respondents, my lord, to respond the enforcement officers, so that, my lord, I can function as per the agreement which is existing today.
Yes.
Now, my lord, today we cannot question whether the validity, because lordship had already undertaken that exercise, but unfortunately it could not be concluded because of the, my lord, action.
No, this hearing today,
lordship,
it's on the premise that your lease subsists, that's all.
Exactly, my lord.
That's all.
And it has not been,
yes.
Exactly, my lord.
Because
That has not been decided.
Yes.
Lordship was on the verge of deciding it.
Yes, yes, Mr.
Yes, my lord.
Yes.
The lordship, kindly see the prayer in the miscellaneous application. Page 6.
1 second.
Staff to the lordship will see may be pleased to consider the above, and after hearing the parties may be pleased to direct the state respondent to deploy post the necessary staff to Amserin Weybridge so that petitioner can function Weybridge as per agreement dated 1/6/2022 and stop the operation of Amjeha Weybridge during the pendency of the writ petition. No, nothing wrong. You are right. Always
let
right.
him submit.
No. My friend is right. I was blatant lie and false lie. I will not join on those issues. Sorry. I will not. I will not go to that level. I am not. Now, your lordship, kindly see this direction that I should not have the departmental Weybridge in his vicinity. What right he has in law to say that I can't have departmental Weybridge, my lord? Under which provision of law my friend can ask? He is serving the private interest. He is fleecing the truckers. And I will not run my departmental Weybridge. Why? Because he has filed the case before your lordship. If he files a case before your lordship, I have no right to do anything in law. That is the submission which I have understood correctly. With greatest of respect, my lord, if he files a case and he says that he has a right, then, my lord, the state should not do anything in accordance with law. Your lordship will indict the government. Don't do A or B. We will follow the law. Whatever direction will come, we will follow. But what my friend's whole case is, my lord, with greatest respect, is that I have filed the case. Your lordship is examining. Therefore, he has a right to continue.
Okay.
Yeah, that your lordship is examining is itself a prima facie express case in favor of petitioner. I have not heard this kind of proposition in my entire life, my lord. Yeah, yes, I am hearing, my friend. अभी तो start हुआ है. मैं तो provoke करूँगा. Sorry, I don't want to go into Delhi mode. Sorry. So the thing is that his whole case is, my lord, that he has filed a petition before your lordship, and I should not act as per law.
Yes.
That is his case, prima facie case, express case, and he says that there is an agreement is in his favor. Please show me where is the agreement. Is that agreement as per law, my lord? If that agreement is not as per law, whether he has right to continue the Weybridge, this is a question I put to myself. Because I will come before your lordship, I will say I have my right and my right is being violated by state. Your lordship will indict me and injunct me from.
See, one thing I was like, sorry to interrupt you, but the thing is that his right, as submission flows from the proceedings which were before this court also.
Yes, Sir Lordship.
Okay, a status quo order was passed, he was running it. Now, we have to examine whether the action of the state, in removing the enforcement, whatever officials, had any way, impinges upon his right or has rendered the...
Yes, Your Lordship. Whether your lordship's order has
whether he can still run the weighbridge.
Yes, Your Lordship. Your Lordship is right, because I have to meet that aspect also, because that issue is also germane to the petition, my lord. Now, Your Lordship, kindly see, I will go first, I will deal with this and then I will deal with that. So, my lord, his right to continue the weighbridge comes from the agreement of 1st June 2022. If this agreement would not have been there,
yes,
he has no right to continue with the weighbridge. So, therefore, he has to first establish a prima facie case based on this agreement dated 1st June 2022. Now, Your Lordship will see both agreements are placed on record, 17 and 22. Kindly see the wordings of 17 agreement, my lord. That agreement, Your Lordship will find at page 39. Now, Your Lordship will find the wordings, my lord, is there. The government of Meghalaya represented by Commissioner Transport, first line, my lord. And after party's name, the government has decided for setting up weighbridge at Amsrin on so-and-so. And whereas government had by public notice invited application from the interested party for setting of the weighbridge at so-and-so place for the purpose of weighing and deter overloading transport vehicles on behalf of the government, where licensee had besides submitted the application and application having fulfilled and all was duly accepted by government, and the licensee was given permission to set up the weighbridge. So it was accepted by government, my lord. That is the line. And Your Lordship, see the new agreement. At page 64. There is nothing. No, the agreement is not saying. The very permission of the government is missing in the agreement. And Commissioner Transport is not the government. This is not disputed, my lord. Statutory rules are not disputed, my lord. And kindly see in this light, statutory rule 3, 4, 5, my lord, at page 30.
Who's snoring?
Page 30, my lord. Page. Page 30, my lord.
Yes,
paragraph 3, this rule 3, my lord.
Yes.
Installation of weighbridge devices. The government may install and maintain by itself as many weighbridges for the purpose of section 144 of the Act on such places as it may think necessary or may allow any private person, my lord. Lordship, kindly mark these words. As many weighbridges for the purpose, government may install and maintain by itself. So government has the authority to maintain and install, because what my friend is saying, close down the government weighbridge, which is closer to his. So this is the right which is, or may allow any private person, body or person comply or organization, install and maintain such weighbridges on payment of lease amount to be determined in each case by the government after calling tender. So this is the power which is vested in the government, not in the commissioner. Provided no lease shall be granted to permission by any private person, body or person, company or organization unless such criteria laid down in these rules from the government in transport department is obtained. Now rule 4, my lord, no bridge without permission. Private person, body or company, organization shall not be eligible to obtain lease permission to unless he has so and so made application in writing to government in transport department through commissioner. So this application has to be the government only. And permission has to, and then your Lordship will see Rule 5. In considering the grant of permission, Commissioner of Transport should satisfy himself with the proposed place of installing and operation of weighbridge or national highway, PW, should be fulfilling all these criteria. Now Rule 6, my lord, Commissioner of Transport to forward the application to Secretary Transport Department. After satisfying himself with the application incomplete and meets the requirement as laid down in the aforesaid Rule 4 and 5, Commissioner of Transport shall forward the application with required Secretary Transport Department for issue of permission, my lord. So without permission of the Secretary is sine qua non for having the agreement, my lord. He enters into some collusion. The petitioner who tries to hoodwink the entire system, sabotage the system.
Is facilitated by your own department.
And I'm guilty, my lord. My officer is guilty. I confess, my lord. My officer is guilty. But your lordship, your lordship knows that in the department we have officers at various levels. Ultimately, it's a decision of the secretary, my lord. It's the secretary. The government is the decision is through secretary, my lord. If one officer has colluded with the petitioner, then the petitioner should not take the petitioner is trying to take advantage of collusion. And that is writ large before your lordship. Kindly see renewal also. Now my friend is on renewal. Renewal of permission. Any permission referred to rule in Rule 6 above shall be renewable every 3 years. On such permission shall be granted or renewed unless proposal for grant of renewal of permission, as the case may be, is accompanied by certificate issued by inspector and Government of Meghalaya and so and so. So the ultimate authority under Rule 6 and 7 is the government. So therefore that agreement is a piece of paper which has no value in law. Contract cannot override statutory rules. I need not cite judgment, my lord. Those contracts and the officers who are not authorized to enter into an agreement cannot confer any right or benefit in favor of the petitioner. Yes. So the entire edifice or structure of the case that he is before your lordship, therefore your lordship is examining and therefore is entitled to interim relief, in my humble submission, is not correct proposition of law, my lord. Now coming back to the second or the primary issue, my lord. Kindly see 85 which has been there. Page 85 which has been withdrawn. What right my friend's client will get from this letter and its withdrawal, my lord? Your lordship will have to consider this aspect, my lord, in my humble submission. Page 85.
This has been withdrawn?
Yeah, this has been withdrawn, my lord. You are, and this has been withdrawn and your lordship has granted status quo in the old writ petition, my lord. You are hereby informed that the agreement for operation of weighbridge at Amsrin is extended up to 30th September as conveyed by the government in later dated so and so. So if I withdraw this letter, my lord, that would indicate that this period is over. 30th September to 2023 is over, my lord. After is extended up to 30th September 23. And your lordship, kindly see the, I should not say stupid, the withdrawal, I don't understand the, and your lordship see withdrawal letter. Is that? Yes, new page.
Page 96.
Yes, I'm sorry, page 96, my lord, I'm grateful. Now, I am to inform you that so and so is hereby withdrawn. So extension was up to my lord, 30th September 23. That extension, that period was over. And every time he is getting extension only.
No, you see, once this order is withdrawn, then what is other supporting materials? You go back, supporting materials goes back to that 2022.
No, your lordship. So your lordship will see every time your lordship he is running the weighbridge.
What
and
caused the issuance of this letter?
No, absolutely no. I can't, my lord. That, but what the issue which your lordship would like to examine, whether this withdrawal or existence would have conferred any right on the petitioner or not, my lord. if the letter remains also and it is not withdrawn, my lord, what is going to happen? That
if the letter remains not withdrawn,
so
then
if it is
still alive, to examine whether he is justified in saying that extension is valid and should run at 25.
No, your lordship.
Now, if it is withdrawn, that means that
no, my lord.
bone of contention
I'm
is
sorry.
removed.
There is the issue is, my lord, he is running by virtue of permissions granted by the government time to time, and that permission was up to 30th September, and that is why he challenged that I am entitled to run up to December.
So now, what is the follow up then to this?
This as on today, he has no.
Okay, you have withdrawn this.
This has got no meaning.
Where's the other follow up?
Your lordship,
and so this is the other supplemental action.
Government is not acknowledging the agreement, which is illegal agreement, my lord. Which is that agreement is not an agreement.
So in the underhand way, sir, issuing other orders, you just remove the enforcement.
Your lordship, if the person, if
disable his
I may submit, my lord. The issue is that if he has right only under the agreement, my lord. If that agreement is not with the permission of the government has a right not to depute anyone. If the government, my lord, what is happening? My friend is confusing Commissioner's Transport with the government. They are two different entities, my lord. The agreement, Commissioner Transport, they go and recover money from Commissioner Transport. He is not the authority under the law. So my humble submission is, my lord, he is making mole of this mountain hill, my lord, is making so this is 30th September. And therefore my humble submission, my lord, 30th September 23 is the last date, and this was withdrawn in September. So this December, this has got absolutely, because this was permission was up to this only, because illegal act was being regularized by the government up to 30th September only. That is my, I will say. Because, and the government stand, my lord, in the previous counter affidavit and everywhere, is that there is no permission, and even in my friend's case, there is no permission. He talks about letters, my lord.
Why did the government not want to produce the
Yeah, I have got all correspondences, my lord.
Regarding coming to the early order.
Earlier order, my lord.
I have come back in 2 minutes.
Yes, my lord. This is the entire set. Yes. The entire set, my lord.
2 minutes. I'll just come back 2 minutes.
Given.
LSC to document?
Yes, Your Lordship. Lordship will see the order of the government at 30th May 2022, my Lord.
I tag it already.
The
Tag is there.
tag is there, my Lord. 30th May 2022. The flagged, my Lord. It is flagged. The Honorable High Court of Meghalaya, while passing this one, so, my Lord, Transport Department is an appropriate.
That order we've seen, yes.
Yes, Your Lordship. And Your Lordship will see the correspondences which have been referred here, my Lord.
Yes.
Forwarded in original to Transport Department on 11th May. That is first letter, my Lord. Then Your Lordship will see 20th May. And third letter is, my Lord, 11th May, 20th May.
Where is that?
And Your Lordship, in the middle of the page, it is referred, there are three letters referred.
Yes.
First is 11th May, my Lord.
Yes.
And second is 20th May, my Lord. And the referred, my Lord. And kindly see the 11th May letter, my Lord, on next page.
1 second. 20. Yes. Yes.
11th May letter, my Lord. In this connection, I have to inform you that the license says so and so has expired. The license has moved the code for renewal, which has not renewed till date. In regard thereof, licensee moved the code. Matter was lying pending till date. In the meantime, department requested the waiveries temporarily to ensure that there is no disruption, loss. Till decision taken on the Honorable High Court in Meghalaya and judgment dated so and so has allowed the petitioner the moved code for renewal within a week, which is to be processed by within a month. Copy license has moved the department for renewal so and so, which is concluded. Government is requested to kindly accord approval for renewal as per court direction, my Lord. Then, my Lord, these letters are there.
And the next is 25, 22?
Yes, my Lord.
Yes.
And all these letters, my Lord. Then 20th May. Kindly approve reminder, my Lord. And then 20th May, my Lord. Contempt of court order, my Lord. 20th May.
Where's contempt of court order?
He says in the letter reminder of 20th May, my Lord, in the bottom. In this regard, government is requested to kindly accord approval for renewal of agreement as per direction to avoid contempt of bottom, Your Lordship, 20th May.
They meant 20th May.
And 20th May, Lordship will see in 20th May a reminder, reminder, and bottom, Your Lordship will find. Government is requested to kindly accord approval for
this
renewal.
Is for some Peninsula Way Bridge.
Yes, they are all bridges, every bridges we have put it here, my Lord. All three way bridges, my Lord. Because all were part of the. And then page 50, my Lord.
Let's avoid contempt orders.
Yes. And page 50,
this is
sorry.
very serious.
Your Lordship will see, and then Your Lordship will. Yes, Your Lordship. And then what is the government is saying? 14 July 2023. We are extending only 3 months. Permission is only. You are hereby informed that agreement for operation of weighbridge is extended up to 30th September as conveyed by government. So it's only 3 months of order which is being passed time to time. These orders are not under challenge, my Lord.
No, they were not in the public domain.
You know, and this is the letter which is addressed to the licensee only, my Lord. That you are getting permission for 3 months only. So the licensee knows that otherwise he would say, why are you extending the agreement for 3 months only? When I have agreement for 3 years, government has approved. So withdrawal in my respectful submission.
Then you have to put it by affidavit.
I will file the affidavit, my Lord, placing all these material on record. But for the limited purpose of interim relief, my Lord, kindly see 2 aspects of the matter, my Lord. The agreement period is over, my Lord. The agreement is over. Even renewal period, if he would have got the renewal of the agreement, that would have been also over by December 23, my Lord.
You'll pass orders, yes.
Yes, oblige, my Lord. Grateful.
My Lord, then you file affidavit.
Lordship. So far, I understand the main case, state will file an affidavit. So far the interim is concerned, my lord, my prayer is this, your lordship. Lordship will see the facts and situation, your lordship. In the first round of litigation, my lord, lordship had taken up the exercise to determine whether, my lord, that renewal agreement was correctly done or not. That exercise was pending.
Yes.
Lordship has granted, my lord, otherwise lordship would not have granted me a status quo.
No,
Being prima facie satisfied, my lord has granted me a stay order. They had withdrawn.
Orders.
My lord, so, my lord, this is a case, my lord, fit case, which call for, my lord, an interim protection, your lordship. Other thing, your lordship can examine, definitely, I understand.
Hearing.
Obliged.
Item 12.
All the parties are here. Where's your, you file your...
Your Lordship, I'll be filing.
No, have the file. Last time, John, no. Prepared means the sense that this matter was kept which is before vacations so that the court can examine at leisure and, pass orders. But then, where's the last order? If I get now only, I got copy.
No, Your Lordship.
Then, this is by PR petitioners.
This is by 4, 5 and 6.
Yeah, what about Dr. Moska? You already filed.
We have not filed. Well.
You're filing today. You already filed, correct? No. Who did I file last time?
No one has filed, Your Lordship.
No one has filed.
No one has filed.
I was under the impression that only 4, 5, and 6 remain to be filed.
Your Lordship, on the last occasion, we had said that we'll file it on when the matter is taken up again.
So it's ready today.
Yes, Your Lordship.
You file it.
I'll file it in sometime, Your Lordship. It's not changed the date.
Yours is ready.
I've already
Yours,
filed it.
City Council, ready.
I'll file it tomorrow morning.
Tomorrow?
I'll give to court martial.
Then we'll have oral arguments then, if we're not going to file. The whole purpose of giving written submissions was that, that holidays were coming. So, to avoid, any loss of time, since there was no time, the written submissions then...
My Lord, in fact, if I may submit, my Lord, this case is covered by a judgment of the Supreme Court.
Yes,
recent judgment.
Ms. P. Chetri is very well aware of that also.
Yeah, it's a very recent judgment, and the facts squarely fit into this, my Lord.
That is why, because of that, last time I had told petitioners, look, there are few decisions which are, even of our own High Court, which are operating against, against them.
Yes.
So that is why, and also in view of the, the circumstances which appointments were made in this instance. So that's why MSP Chetri said, okay, fine, I'll examine the judgments, and I hope she can, meet them in arguments.
Your Lordship, if I may, I would like to defer, Your Lordship. That judgment of the Honorable Supreme Court does not squarely cover our case.
That is
so
what.
that I have written in my written submissions, Your Lordship.
You file it, we'll hear you also. We'll have all arguments since we have lots of time.
My Lord, I've just given the bullet points.
Your Lordship, I have annexed few judgments also.
We'll have it, then you file it, then before filing we have just one hearing, that's it. Okay. Yes, written arguments will file on behalf of the petitioners and also respondent 4, 5, and 6. Dr. N. Mozika, on behalf of respondents number 1, 2, and 3. Please, how much time? 1 week's time?
2 days time.
2 days time to file the submissions. As also, 2 and 3. Dr. N. Mozika, on behalf of respondent number 1, submits that with the submission will be filed within 2 days. So also, MSZ in on behalf of 2 and 3. This is matter for hearing. After 1 week, but 1 week, then we'll hear it. Now we have lots of time, we can hear it aram se.
Yes, Your Lordship.
17.
Obliged, Your Lordship.
Please, Your Lordship.
Start.
Your Lordship, I humbly pray 2 weeks of accommodation may be given.
Then why was it mentioned in the outset, in the morning?
Actually, Your Lordship, we need to seek some instruction from the petitioner.
What instructions do you need to receive the petitioner? What's the matter about?
This matter is regarding the
Assistant teacher.
Yes,
This
Your
court is
Lordship.
very,
Appointment of-
what do you call it, encouraging to juniors. So if you, in the hearing list, if the matter of junior stands, expected to argue it.
Some accommodation may be given, Your Lordship.
You're not ready with the matter today?
No, Your Lordship.
You read the file?
Yes, I have.
You understand the case?
Not at all.
You don't understand the case?
I do understand, but I need some more.
Who's the people of the state?
Miss Goni, Your Lordship, she's on legs in court number 3.
I'm for the 7, my lord, respondent 7.
Okay,
My appointment is challenged, my lord. And that's
You're Mr. Your name?
L Coach, Your Lordship.
Mr. L. Coach prays that some acknowledgement given and he undertakes to argue the matter in the next date. You'll argue the matter, correct? Next date?
My senior may argue, Your Lordship.
Who's your senior?
MF Kursi.
You can come and sit by your side while you argue, okay? Right. Just up to 1 week. So you give undertaking to court, you have to argue it.
19.
Okay?
Highly obliged.
Highly obliged.
Lordship, here I'm supposed to file, give the calculations. Lordship,
Are you suffering from cold or something?
little bit sore throat.
Yes.
So,
You have not received any copy yet of the documents?
no, not documents, Lordship. It's not documents. The Lordship, according to the last order,
Just satisfaction of the court to
Yes.
see whether the assessment and the thing has been done
the
correctly.
calculations are to be
Correctly, yeah.
given. So, Lordship, the calculation is very simple. In one sheet only I am giving. It's very, very simple calculation.
You're in the matter? Are you in this case?
Yes, Your Lordship.
Who's yours? Who's leading in the case?
Enkhera, Lordship.
Okay, ready with the matter today?
Lordship, we are under the impression that we'll receive the document for computation of the damages.
So calculation amount remitted by establishment.
By establishment
into delay days.
into delay days
Into
into
rate. Rate means?
Rate means it is like according to the delay days plus rate of interest.
Okay, no, okay. Amount remitted, suppose amount like you're saying 547 into delay. Delay is 1,000 days, suppose. And
Suppose.
rate is?
Suppose rate is 37, so it is, and then divided by 365 into 100. I have given the example down. I have written the example. The amount remitted is payable amount. It is not exceeding the payable amount. What is the payable amount? It should not exceed. So as part this calculation, okay, I'll give you the copy, no problem. So as part this calculation, according to the calculation, we used to calculate the damages, how it comes. Now, as per section 32, para 32A of scheme, there are slabs. So according to the slabs, the amount of delays is also there. If the act is there with you,
Okay, problem fine.
the schemes, the Provident Fund
Yes.
scheme.
Employees Foreign Scheme, 1952. Para?
Para 32A. Rate of
Now it
damage.
says recover
Now the
damages for default payment on any contribution.
Recovery of damages for default in payment of any contributions. The
So now
slab
6
is there.
months are above 25 rupees. Then how do you get 37 rupees then?
Not rupees, it's percent. Percentage of areas per annum.
Oh yes.
It is.
Okay, so 6 months about 25%. So 25% works out to?
So if the delay is above 6 months, then it comes to 25%. So in that way, we are calculating the damage rates.
No, you real 37.
This is just an example. 37 is just an example I am saying. 37, it's not percentage, it's rate. So I'm just giving an example. It's just showing an example that, for example, for the month of 2005, April, if this is a delay is this, the payment of delay, then this is the amount, calculation. I'm just giving an example showing.
Yes, MSP Saji today has produced a formula showing the procedure for calculation of damages as given in paragraph 32A of the Employees Provident Fund Scheme 1952. You give him a copy.
Yes, I'll give.
Copy is given to the counsel petitioner. Just a matter of 1 week. Then nothing remains to be said. That means the amounts are correct. You take a call.
Yes, Lordship.
The petitioner to obtain instructions. Yes.
20.
That means it's correct because the delay is there because the payments for earlier periods was quite a long delay.
Yes, long delay.
Your account has been frozen also, or the money has been debited from the account.
Money is
Been debited from the account.
Yes, Lordship.
Okay.
20.
Obliging.
Yes, start.
Please, Your Lordship, I'm just informed my learned senior that the state's affidavit that he shared with them, there's one page which is missing.
Missing, Your Lordship. And
Whose affidavit?
Our affidavit, the state's affidavit.
The court's copy is all right.
That's all right.
their copy is all right, but I have got a repetition of some pages which I did not notice earlier.
What is the? Yes.
Sure, we are ready to take up the matter today, but we were informed by the state respondent that it will take some time today.
Well, you're still ready now also, correct?
Sure, I mean, may I
Where's
be
Mr.
allowed to
Charai,
call
sir?
my senior?
He's on leave.
outside.
What do you want to do then?
Sometime in 2 weeks then?
No, Mr. Essence submits that as there's some discrepancy in the affidavit supplied to other parties. Sometime we going to rectify the same. Accordingly, this is a matter of the 2 weeks. Yes. Like, break rack.
22.
My lord, it's in regard to the payment of bill, my lord, arising out of the active act of work under NIT, my lord.
What construction you did?
This is
painting and renovation of toilet.
Sir, there are 4 items, my lord, were executed, and after execution, the completion certificate was also issued, my lord, and the the work was completed in 31/7 July 22, my lord. Till date, no payment has been made, nor a final bill has been prepared.
Has matter been heard before? No.
Short hearing was there, my lord.
Where's the NIT? Amount is? It's amount 23, so
20, NIT amount is 20.
3 lakhs.
20 lakhs plus, my lord.
Okay. And where's the completion certificate?
Completion certificate is annexure, page 40.
Page? Work order 521.
44,
So
page 45.
The amount 23 lakhs, then he was successful quoting amount 20 lakhs 82,000.
Yes, my lord.
Okay, then?
And accordingly was allotted the work, and work was completed, and the completion certificate by annexure 456, page 45, 46, 45, 46, 44, my lord.
40.
That completion certificate was issued on 22, my lord.
Yes.
12, 4/12/22, 11/22, my lord. November, in the month of November 22. So no payment was made, my lord. Thereafter, legal notice was also issued.
No payment was made, the entire amount?
Entire amount, my lord.
Till now?
Till now, my lord. There, in spite of issuing the completion certificate after full inspection, my lord, the department is claiming that there is some damages, my lord. But till date, no, neither damages has been informed nor calculated also, my lord.
Completion to certify that BS Lingo unsatisfactory. No, 4th November. When do you complete the work totally?
31/7/22.
Yes.
That is the grievances, my lord.
Now, where's the affidavit? What did he say in the affidavit?
In the affidavit, my lord, they are saying that there is some damages, my lord, which is required to be calculated.
Then they can measure it.
But that my lord, we have a dispute in this regard, my lord, that before issuing completion certificate, inspections were completed, my lord. This is done properly, but after that, even after that, if the question of damages arises, my lord, that is unwarranted, and I was not informed even whether there is any damages or not. It is just because of delay for executing the work. The delay was caused, my lord, due to the lockdown and the continuation of classes, my lord, of the university.
Will you dispose of Mr. Sen?
My lord, Lordship is, my lord, so far, my lord, read court, my lord, issuing a direction for bill.
So
The
it's
amounts,
certified, I mean, it's
no, my lord,
completed.
amounts to be acknowledged. Now, here, your Lordship, I have filed an affidavit, not only damages, my lord, there was substantial delay. And there is a stipulation in the agreement clause to, my lord, realize to recover the liquidated damage. Now, my lord, he's saying that he was not informed. Whenever he sought for an extension, we said we are not satisfied. We are extending you time, but we reserve our right to recover the liquidated damages. These letters I have annexed to your Lordships.
Yes. No, I've seen that. That original time completion was up to 4th June 2021. Up to 31/7 has been conserved his office. Ex post facto exchange of time is granted. Was the reasons for this state by other firms satisfied right to recover liquidated damages due to the whatever it is, even then you should have processed it.
No, my lord, he should come forward. He's not coming forward, my lord. He should come, my lord.
Now, by the time now the work will be completed since 1 year or 2 years, again there'll be more, there'll wear and tear be there.
No.
That means there will be no
Liquidation damages, my lord. Liquidation damages, my lord, for the purpose of lordship, my lord, delay. He was supposed to complete this work, my lord, within 3 months. But it took more than 1 year, your lordships.
How do you compute liquidation damages?
My lord, that is there. Entire thing is agreement there, my lord. If they sit down together.
See clause 2?
Yes, my lord. Liquidated damages, my lord, it has not been in. There was no damages, my lord. If it is, my lord, stated that due to the extension of time.
The time of a carrying over his intent tenant shall be strictly observed contractor and shall be, we can't page 16 reckon the date in which the order to commence with the contractor work shall so and so and so. Even to which arrangements being so and so. So
work was completed in the month of July. Completion certificate was given in the month of 11, my lord.
Compensation for delay.
then once you apply this tender conditions and pay him whatever is due.
After adjusting all these things.
Naturally, why you delay it so much? I
No, it's
the
not.
Action, the action of the university is that
No.
if you're going to, it goes to 1% of the contractual amount.
What he is demanding the entire amount.
Let him demand, but let the
That's the contract amount, my lord.
That is what
at least you offer him some amount right now. That after factoring in this.
Lordship, what is this prayer? Writ petition?
Forget the prayer of writ petition. I'm talking about action from the respondents. You offer him amount, say that compensation for delay is calculated that much. You take this amount.
No problem.
Then he'll have recourse to civil proceedings. But you can't just stonewall him and say that, and keep quiet and give him.
But what he is asking for, your lordship, lordship will see the prayer, my lord. That is exactly what he is asking from the university. Page 12, my lord. Pass an order holding that the respondent is liable to pay a final amount of tender work to the tune of rupees 20,82,508.
Get it.
My lord, at page 12.
He has to make maximum prayer. As you know, if you're a petitioner, to make maximum prayers to achieve even 10% of what you desire.
My lord, we are bound by a contract. Clause 2 is very clear and categorical. Whenever he sought extension, my lord, we reminded him we are not satisfied with it.
Delay in payment, Mr. Sense, it is arbitrary. In the sense that if the contract stipulates a certain, we should have gone by it. That's all.
No, we are willing to go by it. But he is not coming forward. We cannot take a unilateral decision. You will have to.
Why not? You're the owner of the contract. In so many cases, they deduct the whole security deposit. They don't give back earnest money. They give you amount, and they give a bill to you that says we have done this because, and you have any quarrel, you go to civil court.
No. What is your lordship's mind? I understand your lordship. So, my lord, after setting aside, my lord, after adjusting all those damages and all, whatever is due.
If he agrees with that, then that means he has recourse to other remedy.
My lord, in my legal notice,
after adjustment, whatever.
No, he's bound by. See, Mr. Sen, we're not in the realm of contract, but certain cases, writ court can issue. They are bound by the contract. You go by it. Now, if they say that there's some delay and all, that should be factored in.
Civil court.
Yes, factored in. If he has a grievance with the excess amount, then he go to civil court. Otherwise, he can't sit for 2-3 years without being paid 1 rupee also.
If your lordship asks us, after adjusting the damages and all, whatever is due to pay him, my lord, we are bound to do it.
My lord, in reply to our legal notice, they have admitted a final amount of rupees 18,95,099.
So
that also we replied. We again replied. We have.
Where's that reply, legal notice? That's what I'm saying. Any admitted amount or something. Yes. Where's that reply?
Yes, my lord.
Wait.
That is in page
53. No, it's not there.
No, my lord. This is one legal notice of 47.
In your page 47?
Yes, page 47, my lord. And there in their reply, my lord, page 49.
Page?
49. And even in their affidavit, my lord,
where's the amount given?
18 lakhs.
Where is that?
It's not mentioned.
Yes, it is.
Last paragraph.
It's last paragraph, my lord.
No, they don't admit.
This is not admission, your lordship. This is not an admission.
The only thing is clause 2, that's it. Disposal of Mr. Nath.
After adjusting, my lord.
My lord, adjustment, my lord, liquidation.
We will not pass any orders on. We just say that you are bound by terms of contract. So it's there's undue delay. You process it within so and so. Whatever you do, it's up to.
My lord, lordship will mention the adjustments.
You're bound by the contract, Mr. Sen.
I understand, your lord. So whatever.
Court cannot go over and above and give directions that you have to go by the contract entered into within him.
No contract.
And for the delay, you factor that in.
Contract that includes, my lord, damages to be adjusted.
Of course, the clause 2 is there.
Clause 2 is there.
Then?
Lordship will indicate, my lord, after taking into consideration, my lord, the relevant provision, including clause 2.
Take down, yes.
But those damages should have been informed also, my lord.
No, they have to be in consultation with you. That's all. After they have to give you an offer first.
I have not been informed by any letter
they
or by.
They will inform you now. Okay, take down. The petitioner is before this court with a prayer for a mandamus to issue to the respondent to release the final amount of the works completed by the petitioner amounting to rupees 20,82,508, 20,82,508, so and so, also for refund of the earnest money deposit amounting to rupees 46,280. Stop. Further prayer made in the writ petition is for direction for the respondents to comply with the terms and conditions of the tender notice and tender agreements. Next paragraph. The brief facts of the case are that the petitioner was the successful bidder for certain works which were to be executed in the buildings of the in the institution of the respondents. Stop. In the said tender agreement, the time for completion was, where's that? Tender agreement.
This is at Annexure 1 of my affidavit.
In the said
3 months.
In the said agreement, which was entered into by the writ petitioner and the respondents, where is that? 3 months.
3 months.
No, the agreement is here.
Work order is there. Page 10 of my annexure, affidavit, Annexure 1.
Where's that? Which paragraph?
Second paragraph.
Yes, Tom, no? As per the work order signed on 5/3/2021, it was stipulated that on the signing of the formal agreement, the writ petitioner was to complete the work within a period of 3 months from the date of the work order. Stop. From the materials on record, it appears that the writ petitioner could not complete the work within the stipulated time for various reasons.
I'm sorry, for the lockdown period, where the laborers also.
I was going to say that, no, for various reasons, including the COVID epidemic, wherein laborers are not available. Stop.
But we have refuted that, my lord.
Doesn't matter. This is
not, because they have a partial lockdown,
yes,
complete lockdown, all these things were there.
Yes.
This is a disputed question of facts.
Yes. Stop. It is noted further that the detailed conditions of contract were also provided wherein it was stipulated that the time allowed for carrying out the work shall be strictly observed. Stop. As the work could be finished within the stipulated time, extension was sought, which was granted. Where's that order which showed that you were to pay compensatory? Where's that? Where's that?
Page 20.
Oral petition.
No, my lord, not my affidavit.
As the work could not be finished within stipulated time. By the writ petitioner and allowed by a letter dated 5th May.
There are two extensions, my lord. One is 27 September 21, one is 5th May 22.
Okay, 5th May 22, and subsequently re-extended by?
My lord, sorry, first one is 27 September 21.
Okay, sorry.
And then 22.
The first one. Where's that first extension? Yes, Thomna? 27 September 2021, allowed by the respondent, and further extension was granted by a letter dated 5th May 2022. So bracket lecture Roman 5, Roman 4, and Roman 7. To the affidavit opposition. Stop. Next paragraph. From the completion certificate with regard to the works which were completed on 4/11, correct?
The completion certificate is 4/11.
Yes.
The work was
So the
completed,
works were completed
31/7.
were then issued by the respondents.
29 July,
Respondents
22.
on.
This
The
completion
work
certificate
complete-
is
No.
21, page 21 of my affidavit.
See, this one in the affidavit, Annexure 8, you say that a first was completed 29 July.
29 July.
Yes.
Right, yeah.
From, no?
From the completion certificate with regard to the works which were completed.
Did on 29, not completion, the first work as per the completion certificate issued on 4/11/2022 was completed on 29 July 2022. Stop. However, as the bills for the said work were not cleared by the respondents, the petitioner has been compelled to come before this court by way of the instant writ application. I have heard the counsel for the parties. Mr. HR, Leonard Counsel Petitioner submits that the writ petition is entitled for the entire contractual amount, inasmuch as the works, notwithstanding the delay, which was caused by unavoidable circumstances, has been completed, and that the respondents are satisfied with the quality of the work and have issued said certificates for the same. Stop. He therefore prays that directions be issued that the respondents clear the entire contractual amount within a stipulated time frame. Stop. Next paragraph. Mr. SR and the council respondents have ever submitted that the bills have not been cleared till date in view of the fact that the computation of the compensation payable by the contractor, by the petitioner for the delay, as given in, where is that clause 2? As provided in clause, where is that clause 2?
It's in page 30 of the writ petition.
30.
30 of the writ petition.
As given.
16.
As given in, Tamna?
Mr. Since the counsel for the respondent, however, has submitted that the bills have not been cleared till date in view of the fact that the computation of the compensation payable by the writ petitioner
On account of delay, as provided in clause 2 of the conditions of contract, have not been completed. Stop. He further submits that the other reason for the delay is that the writ petitioner never approached you.
He was insisting for the entire amount. But without adjusting this, we could not have paid him.
We approached several times, my lord.
Okay, then
thereafter we are bound to issue the.
No, what he is insisting the entire amount. We cannot pay the entire amount, my lord. Whatever is due to him after adjustment, definitely will pay.
Tamna? Nas?
further submits that the other reasons for the delay is
No, form that out. Yes, it doesn't matter. Yes. Next paragraph. Having heard the submissions of counsel with the parties and considering the matter at hand, and considering the materials on record, this court notes at the outset that in a contractual matter, especially for realization of dues, unless the amount is admitted and certified, a mandamus would not normally issue. In the instant case, however, the deadlock that has been reached, as observed, is because of the claim of the petitioner as against the stand of the respondents that they should be compensated as per the conditions of contract for the delay cause. Stop. In that view, the matter, therefore, in order to shorten the matter and not relegate the writ petitioner to other forums for realization of his dues. Stop. It is directed that the respondents process the claim of the petitioner, taking into account the terms and conditions of the contract, as also the factors that have caused a delay, and to thereafter settle the amount as expeditiously as possible. How long will complete exercise?
3 months.
The entire exercise should be completed preferably within a period of, you're saying how much?
As early as possible, my lord. They can do it in 1 month.
As expeditiously as possible.
It's already delayed.
Possibly within a period of 6 weeks.
No, madam, 3 months, Your Lordship. Again,
Okay,
I don't want to come with a application for extension, Your
already
Lordship.
delayed.
3 weeks or 3 months, okay, from the date of this order. With about no direction, petition is disposed of. Just
right.
because want to send you to civil court or running around and take another, that amount become useless. That's only consideration, Mr. Man.
Highly obliged.